noticed that you said you indicated that you like gardening. So there's a lot of types of gardening. What type do you prefer?
I do both vegetable and flower gardening. So I enjoy both. The flowers are pretty to look at, but the vegetables are good to eat. So, and I like salsa.
You do a lot of intake. What separates like regular office stress, office drama into something that's actionable legally?
I get an intake call. A lot of people are calling me at the worst moment of their lives. They've been fired from their job or they are at risk of being fired from their job. So, they're in a very stressful situation. And a lot of times people don't really understand what their rights are. And unfortunately, a lot of people think they have more rights than they actually do have. Ohio is an employment at will state, which means that the employer may fire a person at any time for any reason or no reason at all. That's what the employment at will, I lost the word, sorry. The employment at will doctrine, it's not a law. Employment at will doctrine states that an employer has the right to hire, fire, terminate at any time for any reason or no reason at all. And so the employee likewise has the right to resign for any reason or no reason at all. The employment relationship is essentially a contractual relationship where the employee gives their labor in exchange for pay and benefits, and those contracts are terminable at will, unless it's a union contract or some employees and some professions have employment contracts with their employer. Doctors, nurse practitioners, teachers have contracts, written contracts, but most employees in Ohio especially are employees at will. And so a person calls believing that they have been wrongfully terminated may or may not have a legal claim. So what I'm looking for as they tell their story is whether or not there has been a violation of law, meaning the employer has done something to the employee, for example, that violates federal civil rights law, like the prohibitions against race discrimination, age discrimination, disability discrimination. I'm looking for whether or not the employee falls into some kind of a protected category like a whistleblower, or they're being retaliated against because they opposed unlawful behavior on the part of their employer. Unfortunately, a lot of people believe they have been legally wronged. They think that wrongful discharge is a crime in and of itself, and it just isn't,
So a
usually.
bad decision. I thought there was an unwritten rule of like 2 weeks notice. I guess it works both ways. Like in Ohio, you have the right to quit at any time as well.
Places have an actual policy that says if you don't give notice, then you're not eligible for rehire. But usually it's a policy driven thing. It's not a legal requirement to give notice. Again, depending on whether there's a contract, for example.
I want to go back to the word you said retaliation because in this series I've discussed workman's comp and other things that could make the job environment a little uncomfortable when you're suing or when you're doing something on another thing. Is that what you mean by retaliation? Like I got hurt, I made a claim, and now you're not only treating me badly, you're doing things to either drive me out or downright fire. Is that pitch on retaliation?
Well, as you know, Agee Clymer has a lot of workers' comp clients. And one of the things that happens often when a person is injured at work is that they are then on some kind of work restriction, like they have a physical lifting restriction, or they may be limited to just sitting or whatever their doctor is prescribing in order to aid in the recovery from their injury. Well, the employer has a job they want to have done, and employers don't like light duty. Let's just say that. Most employers would prefer to have their employee fully healthy and doing the job and all the requirements of the job. So there's often some rub there between the employee and the employer when it comes to complying with work restrictions. There is a statute which prohibits retaliation against employees who have filed a workers' comp claim. So that's a specific law.
You'd mentioned also discrimination, and that comes in many forms. As you hear these conversations of people that reach out to you, what evidence do you find helpful to mention or to gather, if you're thinking about moving forward with such a claim?
Well, so these days, explicit expressions of discrimination are not common. Most employers are smart enough not to be using racial epithets to their Black or Latino employees, for example. But there are undercover or implied discriminatory statements. So I'm looking for a bias against the person who I'm speaking to that is targeted at them because of some protected status. For example, because of their race, age, sex, national origin, disability. If the employer is an equal opportunity harasser, so in other words, I often tell people who call me, one of the most common things I tell people who call me is there's no law against your boss being a jerk. And if you're
Okay.
jerk, and if your boss is an equal opportunity harasser, that actually hurts any type of legal claim you may or may not have. I'm looking for the employer who is targeting the person because of some protected status. Maybe they have a disability and they are scrutinizing that person's performance more closely than their non-disabled colleagues. Or maybe they make comments about a female employee calling her aggressive or angry. You look for the subtle signs of discrimination, but obviously any kind of written evidence is always good. Witnesses who are willing to stick their neck out and support somebody's claims is good. I always tell people, make sure that you're keeping copies of emails, make sure you're making notes in a journal about things that are happening, making note of who was there at what time it was. I mean, really keeping good records is important for developing a timeline if you have to down the road.
I'm sorry.
That's
It
it.
seems on the doorstep of discrimination is harassment. So there are major differences. I guess one turns into the other, but one could be soft. But the other is, with discriminate, do you find that it's an ongoing, like I finally had it, or are there like one-time events that like this was out of the blue, this was unacceptable? I tend to picture things like in pie charts. Is it 50-50, or is it more things that have been going on for a while and it just you can't take it, or are there one-time events that, okay, this is what we're going after?
I mean, there are both. Both things happen. First of all, harassment is a form of discrimination. If it's harassment based upon some protected status, again, examples would be a female working in a male dominated field like construction is commonly exposed to commentary, as you might expect, that may be off color. Shop talk, generally speaking, not directed at a person. So let's say that the guys on the construction site make dirty jokes to one another, but they're not directing any bad behavior towards the female herself. She's just in earshot, or sometimes she even participates in the conversations, but it could be, very raunchy or off color type jokes that may not be harassment at all because she participated or it wasn't directed at her. Courts expect people to be a bit thick skinned, not slight insults or one off bad comments generally don't amount to actionable discrimination unless they are coming from somebody in a position of power over the employee.
Okay. So if someone is unsure whether to call or is embarrassed or scared, what would you say to someone to encourage them to take the first step and maybe explain the first step?
Well, when they call here, we have a staff who take our intake calls originally. In other words, they gather up information for me. And then if we believe we can help the person who's calling, we'll set up a longer appointment. But don't hesitate to call. I mean, what doesn't hurt to ask a question. Sometimes we can help and sometimes we can't. But, sometimes I'm able to give people advice and never speak to them again. You know what I mean? That they call with an issue. They want to know if they have any rights in the situation. They want to know the kind of questions they should be asking their employer or the kind of information that they need to give their employer. And sometimes I'm able to tell people, look, you're entitled to FMLA, so you should ask for an FMLA application, or you can ask for an accommodation under the Americans with Disabilities Act. I try to help people through the process so that they never get to the point of losing their job, but usually the cases arise when that does happen.
Well, that's good. It's good to be a trusted resource. I also noticed in your bio that you enjoy motorcycles, and motorcycles give a sense of freedom, but they take precision and smarts to operate. I was wondering, when you go against these rather large employers, does that sense of like, loving freedom and wanting, yet being smart and precision based help you in your plan of attack when it seems like, one person versus a very large company?
Well, there's no denying the fact that large employers have lots of resources and attorneys. But in the end, these cases usually come down to the behaviors of individuals within those big organizations. So, I mean, yeah, there's some sense of the David and Goliath, standing up for the rights of the underdog and so forth. Certainly doesn't hurt my morale.
No, you have to keep doing, and I guess at the end of it, it's an attorney on one side, attorney on the other, and letting the law sort of dictate. So proactively knowing the law, is that something you found in your experience? Is that you've seen enough of things that you can get a quick beat on the process of you have to initiate?
I mean, before I was an attorney, a long time ago, I was a human resources director. I've been an attorney since
Oh,
1997, if that tells you anything. But I've seen these cases from both sides, and I guess I've been at it, learned about how new technology can be used, how employers are using new technology against employees, like for surveillance and so forth. It's all there's enough new development to keep me interested in it, and there's always something to learn. So that helps keep me sharp.
yeah. Is that what drew you to law in the first place? Some people I've just asked different questions and it hit on different things, and some people really have had the experience of working both sides of an issue. We've had some staff that work both for, Social Security Administration and on the private practice. And I didn't realize that you were in HR and all the complexities that entails once you've been into that. And so, I mean, that's got to be a defining advantage to me, even if you speak their
The
language a little
language.
bit during,
Yep.
yeah.
Yep. That's exactly what I was going to say. It helps to be able to speak the language. And when I have an HR manager across from me, I'm taking a deposition, I understand what they're saying and they can tell that I speak their language.
Well, those unwritten sort of cues help in that negotiation, much like I was talking to another partner that indicated that insurance companies know, like they like have this ranking of different law firms of like these people go to trial this many times, this, that. So I guess it's good for the person that to know that, because you always want to avoid litigation, right? Like what percentage go all the way and one percentage is done maybe in arbitration? Like what are the phases of the process?
Well, that's a big question.
Okay. In your best estimate, I won't hold you to the percentages, but are there different size buckets that would,
Yeah.
like a majority? Okay.
The minority of cases go to trial. I would say 5% go to trial. The majority settle. Well, I'm talking about the cases that I take, the majority settle before they get to that point. There are different phases of that. In other words, when I first take somebody on, often I will first begin the process by, after ascertaining what the claims are, if any, send a letter to the employer outlining what we believe they did wrong and inviting them to have a settlement discussion very early on in the process, if my client gives me permission for that.
Right. Okay.
Um, but if we don't settle very early, the next stage in discrimination cases or any allegation of violation of anti-discrimination law has to go first to the Civil Rights Commission. That's a long process. We have to file a charge, and then basically it's kind of a waiting game, but there's an opportunity for mediation there. Once it's clear of that process, and only then can you go to court. And that's both state and federal.
Okay.
So you could live with one case. If you take it all the way to trial, easily you could live with a case for 3 years, I would say, is average.
Okay. So, so again, these intangibles, this experience, speaking the language, all tend to get the cases resolved sooner at a good result for your client, but yet you're prepared through that experience to take it all away if you need to. Does that sum it up?
Yeah, that's very true. Employment cases, I don't know what you know about domestic law, divorces, child custody issues, for example. But employment cases are very akin to those kind of cases in terms of the emotions that are bound up in it. If you think about the amount of time you spend at work, you spend time with those people sometimes way more than your family.
True.
There are a lot of emotions often bound up in employment cases on both sides, strong feelings. And so that's an impediment to settlement. And that's why some of these cases take so long to resolve.
Emotions that you're talking about?
Yeah, I mean, just from my perspective, I am particularly compelled by the cases when people call me who have had long careers at a particular employer, which is not as common as it used to be. And when somebody calls me and says they've been someplace 10 years, I'm thinking, wow, that's pretty good by today's standards. And when
Right.
somebody loses a job that they've had for a long time, that gets my attention because something changed. So what changed? If they were good for 10 years, what happened in year 11?
Right. Is that sometimes like a result of a merger or a new boss, or is it just different policy? Is there any, signs that you've come across?
Yeah, I mean, a lot of these things happen when there's a change in leadership, for sure. Whatever the reason, a lot of long-term employees start to have problems when there's a new boss on the scene. Yes.
Do you we garnered on it, touched on it a little bit. Do you take cases that maybe aren't discrimination, but maybe they're doing something unlawful, like they're not paying overtime, or they're not, something that might be systemic? I won't say class action, but something that might be more than one. That have you got? Is that follow under your peer view?
Yeah, those are called wage and hour cases. They arise out of both federal and state law. It's not, if you have an unpaid overtime claim, for example, that is not a class action under federal law. It's called a collective action. Now I'm getting into the weeds a little bit, but
Okay,
yeah, I
that's
mean,
fine.
I've done those cases because the damages for one person usually aren't a lot. And so sometimes it helps to join together with others who have also been adversely affected by the same violation.
Yeah, I just think that that's in my mind, it's a classic example of what you do. In other words, here's something that's a violation law, but it's maybe not big enough to make the headlines, and it's not, overly emotional, but you do feel like you feel powerless. And I just wanted anybody that happens across this, that if you have a question like that, you take those calls. Just, it might not be like us versus, Walmart. I don't even want to say Walmart, but us versus a large corporation.
Fill in
It
the blank.
could be something like this isn't right. This isn't right. And, I just don't know what to do. Again, I just wanted to, confirm that it's okay for them to call you, because you never know what it's going to lead to. And you've seen this before and can handle it. So
Yeah,
that's always
definitely.
intriguing.
I've what I always try to tell people is, even if they don't have a case, they do have options. So we try to work, whether or not they have a legal claim, we do try to give them something they can use, some bit of advice. Yeah, call.
Well, that's good. And I just wanted to, and there's no cost. You're not going to get a bill in the mail. It's sort of like preliminary. It's a great courtesy that when I met all of you in the boardroom there, it's what you think a law firm should be. A lot of caring people with a lot of diverse backgrounds and experiences coming together to really do what the law is designed to do, and that's, is the thing of rights, and despite your ability to stick up for them yourself. Anyhow, I just appreciate each and every one of you guys that do that day in and day out. Do you find that you still love the law? Does it still draw you in?
Do I love the law? I am committed to the process. It's not a perfect system that we have, our judicial system. It's not perfect, but it's the best one in the world. And yeah, I'm committed to the process. I try to join with other attorneys who are like minded, who are looking to make sure that the law continues to protect employees and to. So, do I love the law? Love's a strong word. I'm committed to it. I guess I love it. Yeah. But I'm not
It's
naive about it. I'm not naive. In other words, a lot of young attorneys are on fire. So,
right.
but my experience has taught me not to be naive.
To modulate it. Yeah, save it, modulate it. Yeah. No, I watch these podcasts that said, pick the torture that you can deal with in Excel. So
Yeah,
so it's just nice to
it's
know,
not
because
torture.
you do. Yeah, I meant that in quotes. The idea is that you do spend a lot of time at your work, and you've done this for a while, and it seems rewarding. And I'm sure that day to day there's challenges like everything else, but it's just nice to see that after all that, you still have a very flexible policy of communication. You're still willing to give outreach, and so with that, if you I just wanted to thank you for your time to sort of talk about these issues, because we think we know them. And I was looking at your bio and I'm like, yeah, I get it. You can practice here, practice there, and a whole mess of acronyms.
Yeah.
Each one has its own pathway and ups and downs and pitfall. And it's just nice to spend some time with you to understand what you do to help people every day. So I appreciate it.
Well, thank you for your time.